Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Dr. Yashwant Rao Bhaskar Rao Deshmukh versus Raghunath Kisan Sendane, wherein the Honorable Supreme Court discussed the important points that are to be considered while deciding an application under Section 5 of the Limitation Act seeking condonation of delay. Section 5 of the Limitation Act provides that whenever any appeal or application is made before a court, such application or appeal may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or application within the stipulated time period. Briefly speaking, an appeal was preferred before a high court that had a delay of 650 days in its filing. The reason for delay was explained as lack of knowledge of the decision of the lower court due to non-service of notice due to change of address. Such plea was not accepted by the High Court for condoning the delay. Hence, the matter traversed to the Supreme Court wherein following important observations were made. Firstly, the court cited the case of Peruman Bhagwati Devoswam versus Bhargavi Amma, wherein it was observed that a. The words sufficient cause in Section 5 may receive a liberal construction where no inaction or negligence or malafide is imputable to the applicant pressing the application for condonation of delay. B. Condonation of delay is a matter of discretion of the court, and Section 5 does not prescribe any particular time limit for exercise of such discretion. C. The length of the delay is immaterial and the cause of the delay must be acceptable for condoning the same. D. Even if a delay is of a very short duration, then also such delay may not be condoned if the explanation or the cause of delay is not found to be satisfactory. E. Once a court accepts the explanation or the cause of delay, then the superior courts must refrain themselves from disturbing such finding of condonation of delay unless the exercise of discretion by the court below is arbitrary or perverse. F. When the court of first instance refuses to condone delay, then the superior court is free to consider the cause shown for the delay afresh, and it is open to such superior court to come to its own finding even untrammeled by the conclusion of the lower court. G. Rules of limitation are not meant to destroy the rights of parties. They are meant to see that parties do not resort to dilatory tactics but seek their remedy promptly. H. There is no presumption that delay in approaching the court is always deliberate, and in every case of delay, there can be some lapse on the part of the litigant concerned. That alone is not enough to turn down his plea and to shut the door against him. If the explanation does not speak of malafides or it is not put forth as part of a dilatory strategy, the court must show utmost consideration to the suitor. But when there is reasonable ground to think that the delay was occasioned by the party deliberately to gain time, then the court should lean against acceptance of the explanation. Secondly, the court noted that the information relating to the status of the judicial proceedings to the litigants is usually given by the respective counsels. If such information is not properly given to the litigating parties by their counsels, then the parties cannot be faulted with. Thirdly, the court opined that when notice of judicial proceedings is not served upon a litigant due to change of address, a lenient view ought to be taken while considering the application for condonation of delay. And lastly, according to the court, appropriate conditions may be imposed while allowing an application for condonation of delay. Thus, the court ultimately allowed the application for condonation of delay in the present case. Those were the observations by the court, so what are my concluding remarks? After reading this case, it could be said that following points need to be considered while considering an application for condonation of delay under Section 5 of the Limitation Act? A. Section 5 provides discretion to the court to condone delay in moving an application if there is sufficient cause. B. Length of the delay is immaterial and the cause of the delay is relevant. C. Rules of limitation are not meant to destroy the rights of the parties, but to curb the dilatory tactics adopted by them. D. There is no presumption that delay in approaching the court is always deliberate. E. It is the duty of the legal counsels to inform their clients about the dates of hearing. And F. Appropriate conditions may be imposed while allowing an application for condonation of delay. Thus, I hope that the nature and the scope of Section 5 of Limitation Act is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.